Good evening, and welcome to the American Enterprise Institute for the latest installment in our Education Policy Debate Series. I'm Nat Malkus, a Senior Fellow and Deputy Director of Education Policy Studies here at AEI, and an affiliate of the James Q. Wilson Program in K-12 Education Studies. It's great to see everybody here in person at AEI HQ. Welcome to those who are viewing online, and for our friends viewing through C-SPAN. In September 1992, the first charter school in America opened its doors. Charters were a new and different type of public school, distinct from district-run public schools. They were tuition-free and funded by the government, but operated by private organizations. Compared to traditional district schools, they had more autonomy over curriculum, hiring, and other decisions. But charters were not private schools, as most consider them. Generally, they admit students by lottery, and none have ever been explicitly religious. Since 1992, charters have grown, up to about 450,000 in 2000 to 3.7 million in 2022-2023. Though their growth has slowed somewhat in recent years, today charters educate about 7% of American students. In June 2023, an Oklahoma charter school board made a decision that could fundamentally alter the charter school sector. They approved the nation's first religious charter school, St. Isidore of Seville Catholic Virtual School. To be clear, St. Isidore would be a charter school. It would be operated by the Catholic Church, and it would teach Catholic theology as truth. Predictably, St. Isidore's was challenged in court, and the Oklahoma Supreme Court blocked it, finding that a religious charter school runs counter to the state's constitution. In May of 2025, the U.S. Supreme Court will hear this case and will consider whether a religious charter school violates the separation of church and state, and whether denying a charter school application because the school is Catholic constitutes illegal religious discrimination. This case raises a host of legal questions. Are charter schools public or private? What makes something a public school anyway? Would religious charters threaten constitutional rights of teachers and students? These and many other questions center on whether allowing religious charter schools is right in terms of the law. The case also raises a raft of education policy questions. Would religious charter schools be limited to Oklahoma? Would they be open to other states? Would other states limit charter schools writ large to prevent charter schools from being approved there? Would religious charter schools help or hurt the rapidly expanding broader school choice movement? Would they provide aid for struggling Catholic schools, or would they bring new struggles? These questions center on whether religious charters are right in terms of education policy. All these questions have the makings for a debate, and tonight we're going to have it. On the motion, the U.S. Supreme Court should rule in favor of Oklahoma's religious charter school. It's right on the law and on policy. Tonight's debate will proceed in an orderly fashion. We're going to start here with an initial vote, and then we'll have 3-minute opening statements from our debaters, who I'll introduce in just a moment. Then we'll have about 30 minutes of moderated Q&A, where I get to answer the questions, and about 15 minutes of audience Q&A, where you get to answer the questions. Then we'll have 2 minutes closing statements, and we'll have a final vote. And whoever changes the opinion of the audience the most in their favor will win the debate. Now, if you're online or watching on C-SPAN, we want you to be able to ask our debaters questions at that time, too. You can submit those questions on Twitter, I think they call it X now, with a hashtag. It's hashtag AEI Religious Charters. Or you can email those questions to Annika Hernandez at aei.org. You can find her email on the confirmation email you got when you registered. Our debate today here at AEI HQ will be followed by a wine and cheese reception, so join us for drinks and discussion. For those of you who are watching online or on C-SPAN, try and make it out next time. I'll buy you a drink then. Finally, please silence your cell phones, but don't put them away. We're going to need them to vote on the motion. Now, Before I ask you to vote, I want to be very clear. The Supreme Court can only consider legal arguments, but we're asking you to do more. As we've put into the motion, we want you to consider this question on both the legal and policy grounds. So I'm going to show you how to vote here, and then I'm going to ask at the same time for my debaters to come up, and I will introduce them. On screen here is a QR code, and you can point to that, or you can go to this web address below, and you can vote yes or for the motion or against the motion. Are you for the motion? The U.S. Supreme Court should rule in favor of Oklahoma's religious charter school. It's right on the law and policy, or vote against. While you're voting, I'll ask my debaters to come and take the stage. So while you're voting, and you only have about a minute to do so, we have a great set of debaters. I'm so thankful for you all for making the trip. Let me introduce them. Arguing for the motion, we have Josh Dunn and Andy Smerick. Josh Dunn is the Executive Director of the Institute for American Civics at the University of Tennessee, Knoxville. And previously, he was the Executive Director of the Center for the Study of Government and the Individual at the University of Colorado in Colorado Springs. Josh specializes in the influence of the courts on education, and his research and writings have appeared in the New York Times, the Wall Street Journal, the Post, and he earned his PhD from the University of Virginia. Josh, welcome. Andy Smerick is a senior fellow at the Manhattan Institute. Previously, he served as the chair of the Maryland Higher Education Commission and president of the Maryland State Board of Education. He was also my former colleague here at AEI before we lost him. He also served as an aide to the White House Domestic Policy Council under George W. Bush, Deputy Assistant Secretary at the U.S. Department of Education. Andy's helped found a college prep charter school, the National Alliance for Public Charter Schools, and the education reform nonprofit 50CAN. And he holds a master's in public management from the University of Maryland. Go Terps. We also have, arguing against the motion, no less of a duo, Derek Black and Kathleen Porter McGee. Derek Black is the Ernest F. Hollings Chair in Constitutional Law at the University of South Carolina School of Law. There he directs the school's Constitutional Law Center. Previously, he was the founding director of the Education Rights Center at Howard University School of Law. Derek specializes in the intersection of constitutional law and public education, and his research has been published widely, including in the Yale and Stanford Law Reviews, and he earned his JD from the University of North Carolina. And finally, Kathleen Porter McGee is the managing partner of Leadership Roundtable, a Catholic nonprofit, and an adjunct fellow at the Manhattan Institute. We have Manhattan versus Manhattan here. She's a former superintendent of partnership schools, a network of urban Catholic schools in New York and Cleveland, and before that, she served in leadership at the College Board, Achievement First, the Archdiocese of Washington, D.C., and the Thomas B. Fordham Institute. She holds a master's in education policy and leadership from GW. I'd like my audience to welcome our debaters. All right, we're going to start this out with opening statements. You're limited to 3 minutes, and I will hold time. We'll start off with Andy Smerick arguing for the motion.
Religious charters are right on the law, they're right on policy. They'd be great for kids, great for communities, great for American pluralism. They're also the clear next step in America's efforts to expand K-12 diversity. And best of all, they would unite the two most important strands of K-12 reform of the past half century, choice and accountability. Now, 35 years ago, chartering revolutionized public education. For 150 years, all of America's public schools were government-run schools. Accordingly, we all thought that government-run schools and public schools were synonymous. But via chartering, states bisected public education into two sectors. Some public schools would be run by the government and some by nonprofits. Charter laws were very clear that this would be a new sector of public education that was non-governmental. They were not operated by the government, their teachers were not employed by the government, they weren't even enrolled like traditional government-run schools. Now, private entities partner with the government to accomplish public goals all the time. everything from foster care to clinics and social services. In these cases, the nonprofit retains its private character in most cases. It does not become a government entity. That is why there are so many faith-based organizations engaged in government work today. In fact, in 3 recent US Supreme Court cases, the court decided that any time that a government opens up the operation of some sort of program to nonprofits, that they cannot exclude, they cannot single out faith-based groups for exclusion. That is anti-religious discrimination. Some opponents of faith-based charter schools are just operating, I believe, with pre-1991 thinking. They believe that all public schools are government-run schools. But chartering allows nonprofits to run public schools, and because religious groups cannot be excluded when the government opens up a program to nonprofits, we cannot exclude faith-based groups from running charter schools. A Montessori group can run a Montessori charter. A social justice group can run a social justice charter. A faith-based group needs to be able to run a faith-based charter. Now, some people think that this would upend public education. Far from it. All district and state-run public schools will forever be secular. The vast majority of charter schools will forever be secular. This would simply allow a faith-based group to submit an application to run a school consistent with its principles. I suspect that about 1% of charters would be faith-based after a decade. Some people think this would be bad for faith-based education because partnering with the government could compromise the religious character of the school. I say let faith-based communities figure that out for themselves. They may decide that that concern is unwarranted. If they think it's real, they don't have to run a faith-based charter. Lastly, public schooling today is producing poor academic results and parents are frustrated. The need for accountability and choice is real. Faith-based charters would provide both of those things. They would provide new options for families and do it with performance-based contracts. If we want to expand choice and have accountability, faith-based charters is a way to do it.
Thank you, Andy Smerick. And now, with an opening statement arguing against the motion, Derek Black.
In this case, it's pretty simple. It boils down to the simple question of whether charter schools are state actors, or, as we often say, public schools. And if they are public schools, then they are subject to the U.S. Constitution like every other public school in this country. And the Constitution prohibits public schools from using their power to coerce or indoctrinate religion. And the question of whether they are state actors, whether they are public schools, has already been answered by statutes in 46 states. First, these state statutes explicitly declare them to be public schools. Second, the charter schools only come into existence by virtue of state legislatures authorizing them and establishing them. They only operate by virtue of drawing on money that comes out of the same public education budget as the rest of the public schools in the state and is factored based upon the school funding formulas themselves. If it walks like a duck, if it quacks like a duck, folks, it's a duck, and it definitely is not a fish. The other side says that public charter schools are private because, from my perspective, and I don't mean these particular individuals, they don't care about the Constitution. They don't really care about the broader implications of the marriage between church and state. They just want what they want. They want the state to pay for religious education because, well, they want the state to pay for religious education. And now they want to muddy up the waters of what a charter school is enough to convince us that the Constitution actually requires the state to pay for religious education. But in a constitutional democracy, there are some things that we don't put to a popularity contest. There are some things we don't accept even when they don't give us the answers that we want. Those things are in the Bill of Rights. And the most fundamental of them is that the government shall not establish religion. It shall not collect taxes from citizens and deposit them into the coffers of churches. It shall not offer private parties the power of the state to coerce citizens into religious ideas and activities, and that's what a religious charter would do. Now, like any good sleight of hand, the other side will distract you with something that looks interesting but has no bearing on the issue. And Andy spoiled my spoiling of the trick, which is to say that they enlist nonprofit private parties to run charter schools and give them latitude that regular public schools don't have. So what? Ask yourself, if the District of Columbia, Virginia, or Maryland woke up tomorrow and decided that public school students might eat a little bit more at lunch if they invited Subway in to make the sandwiches, right? Would that transform it from a public school lunch to a private school lunch? Could Subway ask non-believers to get out of the lunch line? Could Subway require that the children ask prayers before they ate their lunch? Or would it remain the same public school lunch, just served by a different set of hands and tasting a little better? I think you know the answer to that question.
All right, thank you, Derek. And arguing second for the motion, Josh Dunn.
6 or 7 years ago, I would have been skeptical on this question. I remember the first time someone asked me about the possibility of religious charter schools, and I thought it was a rather bizarre question. I couldn't even imagine the court even considering this, but yet here we are today. So I came around on this question, and the person who persuaded me that the court should rule in favor of Oklahoma was none other than Justice Stephen Breyer. Let me explain. In a trilogy of cases, Trinity Lutheran versus Comer, Espinoza versus Montana, and Carson versus Macon, the Supreme Court essentially eliminated the constitutionality of Blaine amendments. In Oklahoma, the provision of the Constitution in that state used to strike down St. Isidore was its Blaine amendment. The Supreme Court, by and large, ruled that Blaine amendments violate the Constitution. Justice Breyer noted a problem with this in his dissent in Espinoza. He said, if making scholarships available to only secular non-public schools exerts coercive pressure on parents whose faith impels them to enroll their children in religious schools, then how is a state's decision to fund only secular public schools any less coercive? Then he went on, what about charter schools? States vary widely in how they permit charter schools to be structured, funded, and controlled. How would the majority's rule distinguish between those states in which support for charter schools is akin to public school funding and those in which it triggers a constitutional obligation to fund private religious schools? I think what Justice Breyer was noting was that the doctrine that the Supreme Court was articulating essentially requires this outcome. Unfortunately for Justice Breyer, he joined the majority in the first of those cases, Trinity Lutheran versus Comer. There was no real principled way, though, to distinguish the move from Trinity Lutheran versus Comer to those latter two cases. You can see part of the problem if you consider the fact that there could be two essentially identical schools. In fact, there's an environmental charter school in Los Angeles, Environmental Charter Schools, it's called. It's a nonprofit corporation emphasizing environmental sustainability and social equity. Let's say that there were a religious organization that wanted to create an environmental charter school with the exact same mission, but it was done for a religious reason, something like Creation Justice Ministries. Under the reasoning of the Oklahoma Supreme Court, you could allow the first but not the second. That has to be a violation of the Free Exercise Clause. You also turn to the Establishment Clause. The Establishment Clause does not forbid the creation of religious charter schools. The court essentially eliminated the grounds for that in a case called Kennedy versus Bremerton just a few years ago. The lemon test is no longer there. We don't know exactly what test they're using going forward, but I think that what is there would in no way forbid the creation of charter schools run by private religious organizations. Furthermore, I think that it would create doctrinal and policy chaos if you were to rule against St. Isidore. In the Q&A, we can perhaps get into that. And in the end, unpleasant participants that could arise aren't really a concern, I think. So in short, St. Isidore's exclusion violates the Free Exercise Clause, misreads the Establishment Clause, would create doctrinal and policy chaos, and it depends on an unconstitutional understanding of the nature of rights.
Thank you, Josh. And last but certainly not least, Kathleen Porter-McGee, arguing against the motion.
Thank you. So before I begin, I want to share a few quick framing thoughts to ground my argument. For starters, this is actually my second formal school choice debate. My first was actually in 1991 when I was a junior in high school and proposed a voucher bill at a high school mock Congress. So I come to this debate honestly and as an ardent and lifelong supporter of school choice. I've also been a ground level educator for most of my career, and I understand that the act of running schools, which involves seeing the downstream implications and unintended consequences of good policy ideas, is critical to understanding what separates good policy from bad. And so the perspective that I share with you today is drawn not only from policy and research, but it is also grounded in my lived experience, both as a charter school leader and also as a Catholic school superintendent. With that as background, I want to underscore that regardless of what the Supreme Court decides about their constitutionality, religious charters are not wise, and they will likely work against their intended goal of expanding choice and supporting religious liberty. So first, to understand the wisdom of creating religious charter schools, it's helpful to go back to the origins of the charter movement. Why were they created in the first place? From the beginning, they were meant to be islands of innovation in the public sphere, largely free from the bureaucratic and regulatory constraints that made innovation more difficult in traditional public schools. The freedom was intended to come with accountability. Rather than being beholden to compliance-focused regulations, charter schools were to be authorized by a government-sponsored entity that would provide oversight and accountability. The belief was if a charter school was not living up to its promise, it would be shut down. This vision of charter schools as incubators of innovation was initially game-changing. Early charter school leaders changed the conversation about student achievement by defying the odds and proving what was possible in this freedom autonomy framework. Yet over time, the lines between traditional public and charter schools have blurred. In particular, regulations have increased significantly, as they often do when the government is in the driver's seat. And that means today the only sector that remains truly free from excessive government regulation and oversight is the private school sector. And that's why we should not be looking for religious schools to become more like charters. Instead, we should be finding ways for charters to be freed from regulation so they can operate more like the innovative private schools they were meant to emulate. My second argument focuses on what's at risk for religious institutions that might pursue charter authorization. In short, religious charters risk losing their faith to maintain their funding. Those of us who have served in urban Catholic schools understand that the current funding model certainly doesn't add up. And many hope that religious charters will be a lifeline that will open a spigot and allow public funding to flow freely. But we should proceed with extreme caution here. Historical examples show us how this can play out. Across sectors, as faith-based institutions have partnered with the state, they have encountered growing waves of influence and manipulation through regulation. And today, at a moment when some religious beliefs are seen as hostile to the values that many public schools aim to teach, the line between accountability and institutional autonomy is more blurred than ever. And the price of public partnership is often a loss of control over curriculum, hiring, and religious formation. In the end, religious liberty is not just about what the Constitution allows, it's also about what the church can do without compromise. And when we build our schools on the foundation of government contracts, we risk ceding our freedom in pursuit of our funding.
All right, thank you very much, Kathleen. Not much to talk about here. Let me start out with a zooming out question. What's at stake here? I mean, what are the real tangible impacts that this Supreme Court case could have on the American education system? What are the kind of things that the public, that students, and parents might see as a result of this decision? Andy?
Well, one, you will get a broader array of schools, choice-based schools, that parents can access. I think that's a good thing. We will have the opportunity for faith-based schools to be fuller participants in American pluralism, the work of the government advancing the common good, which is great. I also think it's extraordinarily important for folks who are skeptical of school choice and the growth of ESAs and vouchers and so forth to recognize how important this could be. This is a way of getting new choice options, including faith-based options, in the context of performance-based accountability. So it could be a new wave of schools where we can actually figure out how the kids are doing so it can advance our interest of the public interest. And the last thing I'd probably say about this is I am always told in all of the work that I've done in public education that some reform is going to blow up the world, that the apocalypse is right around the corner. They said that about accountability. They said that about charters. They said that about school choice. They said that about teacher certification reform. I've used this tactic myself, so I'm aware of it. This big fear that, oh my goodness, the sky is going to fall. A small number of religious-based organizations may run a school that is performance-based accountability. I think that's wonderful, and it's not going to change the world.
Kathleen, a response? What are the stakes here?
I think the stakes are the continued destruction of the sector of American Catholic schools as we know it. So I think over the past 2 decades, we've witnessed the quiet devastation of Catholic schools in urban areas, and the numbers are really staggering. Since 2000, 1,400 Catholic schools, most of them urban schools that serve the urban poor, have closed, and most of those are in communities with charter schools. And essentially, over that past 2 decades, we have had policies that preference charter schools over privately funded scholarships for Catholic private and parochial education. And that preference of charters over tax credits, vouchers, and ESAs has led to the destruction of the Catholic school system as we know it, particularly the urban Catholic school system. I think we will continue to see that devastation. So I think the stakes are incredibly high. The American system of Catholic schools as we know it is the largest non-public school system in the world. And it will not be for long if we continue to bias in favor of charters over private schools. school choice. And I want to be really clear too, the devastation of urban Catholic schools is not the free market at work. This is the government putting its thumb on the scale of two systems, the traditional public and the charter system, at the expense of the third. And so I think right now what we should be doing is investing in choice without constraint or compromise.
And so to folks who would say, Kathleen, you seem to be arguing for the other side, let them charter, what's the response? Why do you say, no, chartering is not the solution for the sort of struggling urban Catholic schools?
Because I don't think religious institutions should have to ask permission from the government to exist. Right now, private schools can exist. They have the right to exist to start schools. They have been founded by religious communities for religious communities. I think we should be looking for money follows the child, private school choice, not for permission from government authorized contracts and charters. And I think the more we preference that, the more the government can use its regulatory power to infringe on the rights of religious institutions. And I think we've seen this in other countries as well. So if we look at our neighbors in the north, they have a more pluralistic government-controlled system, and it has been devastating for Catholic education in Quebec in particular, where the Catholic schools in Quebec have been absorbed into a broader, sort of this utopian vision where we're going to fund all schools, but they are slowly losing their religious identity because of that. Or they're being forced to face costly litigation just to beg for permission to be able to teach the faith in a way that is not values neutral. I do not think we should make that compromise.
So I'm gonna just say this multiple times tonight. I'm gonna dance between education policy and the law, and I want to get to the law for a minute. So Derek, on this question, how do you see the stakes?
I mean, look, the stakes here are rights, money, and efficiency. We can't pick and choose. If charter schools are not subject to the Establishment Clause, then they're not subject to the Equal Protection Clause. If they're not subject to the Establishment Clause, they're not subject to due process. And that means that 3.7 million students who are currently in charter schools just lost their right to free speech, just lost their right to due process, just lost their right to fair discipline, right? So we can't pick and choose and say, well, it's okay to sort of use religion, but we're going to ignore the other parts of the Constitution. On the money, right, coming back to the policy, our public schools across this country, many of them are woefully underfunded. And so what we're talking about is taking the education financial pie and slicing it up into smaller pieces and becoming more and more inefficient. And for those who are worried about efficiency, more schools, particularly in our rural communities, which are already struggling with under-enrollment, right? The finances just don't add up when we add additional players into that system there.
Josh, any thoughts on the stakes?
Certainly. So I agree with Andy that there probably aren't going to be a whole lot of faith-based charter schools that will emerge because of this. Although I do think in urban areas, you will see it would be a lifeline for Catholic schools. What we've seen is that when charter schools move into urban areas, that's when, as you mentioned, Kathleen, that you see a dramatic decline in Catholic schools. So in a way, your question, I think, is right. Back to Nat, to Kathleen, that aren't you arguing in favor of this? This could actually save them. And I think that's where you'll see the most of them. Under the law, I think that this could be Justice Breyer's nightmare, because in his dissents in these cases, he also seemed to indicate that the logic of the court's reasoning in that trilogy of cases was pointing towards individual choice in education. And so if they rule in favor of St. Isidore, I do think that you'll see people start to develop law schools where they're going to say that education itself is an otherwise available benefit. That's the precise language that the courts use, and they will try to use that as leverage to get essentially something like ESAs or vouchers almost mandated by the judicial system.
Two very quick things. The first is Kathleen in her career has done extraordinary work, and she and other Catholic educators deserve not just a pat on the back, but the recognition that they've been doing something for the public good on the cheap for way too long. The number of young souls, human beings who were given a chance thanks to America's Catholic schools, it's astonishing. And the fact that they have had to do that in the context of competition and thousands have closed is a real shame. This is the opportunity to say to the Catholic schools community, but also Jewish day schools and Lutheran schools, you can remain as private for as long as you want to in the private school sector. But if you think you can do your mission under a charter school context, you have the right to do that. That will come with additional funding. It'll come with performance-based accountability, but this is a way for them to advance their mission so they don't have to constantly beg for $4,000 a year. Maybe they can get $12,000 a year to do this work. And the last thing I have to say is The idea that this is radical only if you forget 40 years of American history. I'm old enough to remember the book Reinventing Government, which came out. I worked for the Bush administration when there was an initiative called Faith-Based Neighborhood Activities. For ages and ages and ages in America, nonprofit organizations, including faith-based organizations, have partnered with the government to get things done. That is why the state action doctrine exists. This is just one small addition, addendum to that. There are rules for making sure that those organizations can do public work, but that they remain there with their private character. We shouldn't act like this is brand new. It's been going on forever, and this is in the best interest of kids and education. This is a non-profit sector of public education.
So I have a question. Go ahead, Derek.
I mean, we're just comparing apples and oranges. And we've heard this about the vouchers in Maine and the other cases. Look, a voucher that gives money to parents and allows them to spend it or reimburses them at a private school has absolutely nothing to do with charter schools, which again only can come into existence by states stamping approval and saying, we are going to make you a public school. We are going to give you money. There is nothing about a charter school that resembles private schools or vouchers. And I hate to say this, and I hope he's not listening, and if I am, he can send me an email. But as I listen to the oral arguments, and we've heard Justice Breyer's name raised twice, I almost fell out of my chair. I really did. Because he clearly doesn't know what a charter school is, right? He was worrying about a thing that need not be worried about, right? And I think that's the sort of, sleight of hand that's being pulled in this debate regularly out there, is that somehow or another, these just happen to be private schools that now want a charter, and that ought to be okay. No, they are state schools. They are free and open to all. They are required to let anyone in regardless of what they believe. They are required to let anyone in regardless of their race, religion, national origin, etc. They do not get to pick and choose, as Nat said earlier. They are public schools, right? The fact that they enlist private actors to help them doesn't mean anything. Look, I'm a private citizen. I say lots of things. I'm saying things right now my governor may not like, my dean may not like. But when I show up tomorrow morning at 10:45 for constitutional law and I step in front of that podium, I become a state actor. My words are not my own anymore. I am not free to indoctrinate students. I am not free to discriminate against them. And so the fact that we have private entities that step into the shoes or step along with government doesn't somehow or another clear the government of its responsibility to make sure that religion doesn't become part of the public school system.
Can I respond to that in two ways? Because I think there's a factual
Very
error.
briefly.
Okay. This case, that just because the government was involved in its creation means that it's a public entity that is going to be controlled as a state actor, is absolutely untrue. Governments, state and federal, are involved in the business of chartering banks, which remain private entities. Corporations have to get a charter, a corporate structure from the government in order to operate. That doesn't mean that they are state actors. Churches get a corporate structure. That does not mean that they are government entities. The second point here is this idea that this is so different than the three other cases. It couldn't be further from the truth. In Trinity Lutheran, the Chief Justice, I'm paraphrasing here, said to Missouri, you did not have to create this program for surfacing playgrounds, but once you did, you cannot exclude religious organizations. He said in the Espinoza case, you did not have to create a tax credit program that involved nonprofits, but once you did, you could not exclude faith-based organizations. In Carson v. Macon, he said, you did not have to create a tuitioning program, but once you did, you cannot exclude faith-based organizations. In this decision, he will write, Oklahoma, you did not have to create chartering that allowed nonprofits to run public schools, but once you did, you could not exclude faith-based organizations.
So let me ask you the
Matt, I'm
question
back at it again.
Yeah.
let me ask the question that stems back this, because we're too legal. We got to get back to the policy. Are you not concerned that if that indeed is the case, that states that have legislatures who are averse to religious charters will not cap charters, that will not hobble the charter sector that currently exists to make sure that new religious charters that are legally required, depending on how this case is decided, don't flourish? Is that not a concern, Andy?
There have been forces aligned against chartering since 1991, and they have been trying their very best to stop chartering from the very start. And there's this old saying, it's attributed to Winston Churchill, you can't negotiate with a tiger when your head's in its mouth. For too long, the charter and choice communities have begun our efforts by capitulating to all of the opponents, saying, we'll do what you want just as long as you're on our team. It wasn't until the choice community decided 5 or 6 years ago that they were going to stop capitulating to all of the concerns of choice opponents and say, we're going to fight this thing and make choice available to all families and all communities. And that's why choice has expanded across the nation. So I would say if there are states that are going to kill chartering and all of the good that it's done for low-income kids across America, just because you're upset that a couple faith-based organizations are going to run some schools for disadvantaged kids, I'm not going to capitulate to that. I say, let's fight that fight.
I think that's exactly what's going to happen, especially in states that are already hostile to charter schools. I mean, I ran Catholic schools in New York, and that is hardly a state that is open to choice policy of any form. And I can imagine a situation for sure, it already has a charter cap right now, and I can imagine a situation for sure where if they were told, in order to continue to charter schools, you have to charter faith-based schools, they would say, great, we are either not going to raise our cap, or if we must raise our cap, we're going to get out of the business of this. So I think this is a major issue, and I think that's why we're seeing charter leaders across the country who were filing amicus briefs, sharing their worries about this case for that reason. I think it is a really serious concern, and I think it could lead to the destruction of chartering or the limit of chartering nationwide.
I've done a little homework for this question, so I'm going to take a moment here. Originalism often comes into play in Supreme Court cases. I want to ask about originalism that's a little different, one that's centered on the original intent of charter laws. The National Charter Schools Founders Library has a bunch of documents on these sort of founding legislators, perspectives on this. I want to read just a few. North Carolina House Speaker Howard Brubaker called charters a very novel issue to still have a public school called a charter school, and that his legislative opponents have a very difficult time arguing this is not a public school system because charters are going to get funding basically the same way the school system has. Florida Governor Jeb Bush, they're independent public schools that have discrete missions. Minnesota State Senator Rashad Young, chartering was to open up K-12 public education system to allow people other than school boards to provide public education. Parents and teachers, the key was to have outside choices so that the K-12 system would be more responsive. So in some sense, an originalist lens might suggest these founders believed they were creating new types of public schools, and they included prohibitions for religiously affiliated charters. So I'm going to ask those arguing for this, is there evidence these founders could have intended otherwise, and does it matter?
Well, I don't think there is evidence that they were considering something else, but sometimes the legal issues take time to develop, and I don't think they could foresee changes in the law and changes in doctrine that we've seen over the past 7 to 8 years. And so there are certain implications of that. So even if that's what they intended, it doesn't necessarily mean that their intent gets to trump the Constitution and what's required by the Free Exercise Clause. So yeah, I think that's probably what they had in mind. But that was 1991, 1992. We get Trinity Lutheran versus Comer in 2017, and things start to dramatically change after that.
So I actually wrote a paper for the National Alliance for Public Charter Schools in 2005 called Original Intent. I'll make sure that it's online so all of you can look at it. I asked this exact question. I looked at the preambles of all of the charter laws that existed at the time because there were lots of people saying things about charter laws that I thought were not true. I'll cut to the chase. There are 18 different purposes for charter schools underneath of their preambles. At that point, number one on the list was expanding options. Of these different purposes, one after another makes it very, very clear that the government was doing its best to create a sector of public education that was not run by the government, public but non-governmental. They created a sector of schools that were run not by the government, whose teachers were not employed by the government, whose teachers would not participate in a collective bargaining agreement with the government, who would be not subject to the same schedules and calendars as the government, who wouldn't necessarily have to have the exact same certification as government schools. In example after example, they were saying these are not government-run schools. So if it doesn't quack like a duck, if it doesn't walk like a duck, it's not a duck.
I got to get in there. So, I mean, on this founder issue, I think one of the things that a lot of folks miss is the state constitutional piece of this, and this is key, right? Because let's put aside the question of whether we can have religious charters. On the question of whether we can have charters at all, right? There were legal challenges, the first and most important of which was in California, where the litigant said, you can't have a charter because guess what? You are funding them with what we call the Common School Fund, which is a fund that's over a century old that is reserved exclusively for the state's public schools. And what did the Supreme Court of California say? These charter schools, as created, are public schools, and therefore they can draw on the common school funds. But here's the key. If you are not a public school, you are not eligible to receive these state funds. These funds have been reserved for over a century, and so that's the little wrinkle that a lot of people miss. It really doesn't even matter whether we're talking about religion or not religion. If they're not public schools, they're not eligible for the funds. But if they are public schools, then they can't become religious.
Let me push on that a little bit. There's two questions I have. The first is, if the court sides with St. Isidore's, is this somehow cabined off for Oklahoma, that this will apply to Oklahoma, or will the decision affect chartering across the country?
Well, I mean, the court could certainly narrow a decision as best it wants to, but I think, the general, look, we started with this idea from the other side was, well, if you have to give public dollars to private religious schools, then you got to give public dollars to private religious charter schools as well. So the slippery slope, I think, continues to sort of move on. So I will say that I don't think it ends with just Oklahoma. And I would also add, going back to California, if California is required by the United States Supreme Court to charter religious charter schools, I believe that California is thereby obligated to shut down its charter school system under its state constitution because the Supreme Court is declaring them to be private actors that really should not be eligible under state constitutional law to receive any public funds.
Josh, I want to ask you about the Blaine amendments. You mentioned them, that they were prohibitions against religious participation in some constitutions, and they are not struck down sort of writ large at this point, I believe.
Depends
but
on
that's
how
the
you,
question.
yeah.
Is this the death knell for Blaine amendments? And if so, what effects would this have about cabining this off for Oklahoma or else?
Yeah, I think
elsewhere?
it doesn't, if they rule in favor of St. Isidore, it spreads across the country. I do think there's a question, say, with California. The problem here is that the states have singled out religious private organizations for exclusion in the program, and then that violates the free exercise clause. So in Oklahoma, the law actually says that any private college or university, private person or private organization can apply and run one, but then it excludes religious ones. That's what violates the free exercise clause. So again, you could have essentially identical schools, but if the motivation is religious on one hand and secular on the other, even if what they end up teaching is exactly alike, then the religious one can't participate. There seems to be a problem there. The Blaine amendments are on life support, if there's any life left to them at all. Maybe Locke versus Davey is still out there. That's a case that has not been struck down, but I think it's probably going to be challenged in relatively short order. So this probably would be an ultimate death knell, because you look at the Oklahoma decision, it starts with its Blaine amendment. Those are constitutional amendments, 37 to 39 states, depending on how you count them, that say you can't provide any money to sectarian institutions. They were largely anti-Catholic. Sectarian meant Catholic at the time that they were added to state constitutions. So it would be the death knell for that. And then they led with that in their brief. Oklahoma led with the Blaine amendment in the brief to the Supreme Court. It struck me as an odd strategic choice given that line of cases. But we'll see what the court says.
Derek, a quick question on this line of cases that is sort of leading towards, I guess, from Carson and may end with St. Isidore's. I don't know if it ends there. But in your reading, are those cases, I mean, they were decided, they are precedents now of some duration. Are they wrong?
Well, I'll be forthright. I was filed amicus briefs not wanting the results in those cases, but they are the law and I respect them. But I don't think they have any bearing here, because ultimately, again, we're talking about whether the state, and looking at a sector of private schools, some of which are religious and some aren't, can or cannot exclude religious schools. I'm fine with the sort of idea that that's religious discrimination, right? You're looking at pre-existing entities. But when we talk about charter schools, right, they come into existence only because the state says, we are authorizing you, we approve your curriculum, we think this meets our state objectives. This isn't about private objectives, this is about public objectives. And so there's really no comparison between a private school, which has its own objectives, and charter schools that are serving the state's objectives.
The Corporation for Public Broadcasting, you guys can look this up, was chartered by Congress. It has the word public in it, chartered by the federal government, and it is a 501c3. It is a private organization. Just because the government is involved in something, just because they put the word public in it, does not mean that it is a government-controlled entity. And once that is the case, then it is a matter of the state action doctrine, which means that if it is separate from the government in all of these important ways, it retains its character as a private organization.
I mean, fair enough, but let's just say this, like, I'm from East Tennessee, I know TVA, which is one of the most important charters this country's ever handed out to the people of the South. But there's a big difference between the TVA charter and the charters that the state of Tennessee hands out. Guess what? People don't get free electricity from the Tennessee Valley Authority. They get free public education. And why do they get free public education? Because unlike all these other charters, we could list 1,000,000 of them, I don't care, education stands on its own because all 50 states are constitutionally obligated to deliver free and equal education for all. They are not obligated to deliver electricity, so if they want to play with the private sector, fine, but we are talking about a unique context in which the state says, help us do our constitutional job.
Kathleen, I want to get you in here and get back to the policy, off the law for a minute. You were the head of partnership schools, ran Catholic schools in urban environments successfully. They're not all succeeding. Some of them are struggling. What about the ultimate question? If the choice is between, and for some schools it probably will be, trying to start a Catholic charter or not having a Catholic school, how do you see this in that light? Because we've talked about many Catholic schools that closed and are no longer there. If the lifeline is there in this desperate a situation, is it not plausible?
So I guess I don't accept the premise of your question, because it says that the only option for struggling Catholic schools is to pursue, in this scenario, would be to pursue a chartering option. The landscape has never looked more promising for private school choice than it has in the past 5 years. For the 20 years that preceded it, you might have been right that charter schools would have been the only option. That is no longer the case. We are on this spring, we have the possibility of a federal tax credit legislation passing, which would provide a lifeline for struggling urban Catholic schools in every state in the country that wouldn't be subject to the regulatory burdens that I think a charter school demand and that it puts on faith formation and other decisions that faith-based institutions have. So I sort of fundamentally reject the question because I don't think that's the option that we face. In fact, I think today we should be doubling down on the fight for private school choice, not capitulating and saying we give up, this is our only path forward. And this is a very real issue. The pressure I get that for charter schools, the funding that could come through will be very seductive. But we have to think about the opportunity costs as faith-based leaders. What are we giving up in terms of autonomy and control and our ability to make decisions that align with our faith and values if we have to go with government authorization?
She warned us. She learned as a junior in high school to debate. She's a ringer. That's why she rejected the premise. Andy, let me ask you the question that Kathleen is begging. If we had unrestricted private school choice, would we need these charters? Would they no longer be a benefit?
Faith-based charters?
Would faith-based charters be sort of necessary or needed on the policy front if we had sort of unrestricted, publicly funded private school choice?
Yeah, so I'm going to reveal myself as sort of being an old-style conservative, not necessarily just a libertarian conservative. That is, I don't think that the market always solves everything by itself. Having been a former charter school authorizer, having been around private schools a long time, I've seen lots of choice-based schools that don't do such a great job for kids, and I don't think that's okay. I love the idea of government funding supporting a wide array of schools because that's consistent with American pluralism and the diversity of our nation, but I also love the idea of accountability. And I like more than just market-based accountability, especially when the interests of low-income disadvantaged kids are at play. So I love the idea of faith-based charters, if for no other reason than it's more in different types of schools, along with contractual obligations, explicit indicators of whether or not students are learning. So great, expansive private school choice, I'm all for it. Also love the idea of performance-based accountability.
All right, I want to remind everybody, I'm going to ask one more question here, and then it's going to be your turn to ask those questions. Again, those watching at the audience, you can get questions in by using the hashtag that is AEI religious charters, and you in the audience, prepare your worst. I think that this, much of the legal case centers on what is a state actor. What is a state actor when it comes to public schools? Maybe what is a public school? So I'm going to ask Derek and Josh, sort of challenge round question here. If you have, I'll limit you to 3 criteria. For a layman, can you, or layperson I should say, can you give us a definition of what a public school is? What defines the duck that we've been searching for in this debate? Derek?
Well, I think first and foremost, a public school is free. I'd say second of all, it's open to all, and I think that's the key. I mean, to some extent, we've been down this road before when we had lots of religious factions fighting with one another over how they were going to finance their schools 150 years ago. And when we put those words open to all, right, and free in our state constitutions, we were defining the distinction between a private school and a state actor. And then finally, it is the coercive power of the state, right? To expel or expel, based upon federal constitutional requirements, but also to compel the children to be there, right? To punish them and be subject to the 8th Amendment when they do it. So ultimately, a state actor has these sort of components of state power. It is open and free to all, and of course, it is bringing the many together as well in one system.
3 criteria, Josh?
Yeah, good question. So I don't necessarily object to Derek's criteria. I just don't know that that would necessarily exclude charter schools because particularly on the question of coercion, these are by definition schools of choice. So many of these questions about coercion are just taken off the table, and particularly some of the Establishment Clause concerns about coercion, which there might be something of a coercion test still lingering there in the court's jurisprudence. So I think I would broadly accept his criteria, but say that charter schools still aren't vacuumed up within that definition, partly because of many of the reasons that we've said, but then also this element of coercion is just isn't there.
I'm going to ask one more quick question and wonder if the religious discrimination that is being prohibited actually hurts Catholic charters. So to Andy and Kathleen, briefly, if Catholic charters accept public money and then, like most other charters now, cannot require students to make, say, a profession of faith, or teachers to say that they believe Catholic theology, isn't that a problem? Andy?
Yes, it could be. I don't want to go too far down this line because we don't know what the court is going to say on this, and I will just concede a point, which is one reason I'll say as an aside why I've been hoping legislatures get involved in this as opposed to courts, but that ship has sailed, which is even if the court comes forward and says charter schools in most states are not state actors, therefore we cannot allow a state to discriminate based on faith. Even if they're allowed to do that, 100 different questions still arise. Does the ministerial exception apply to their teachers? Can they discriminate on who they hire? Which students are they going to allow to apply and then enroll? Will they say, well, magnet schools are public schools and they are selected admission. Should we allow faith-based charters to be public schools that have selective admissions? Lots and lots of different questions about what is in a performance contract, who the authorizer is. I don't think court's going to get into that, but let's just say that if this court case goes the way that I think it is, state legislators need to step up fast and answer these questions.
Kathleen?
Yeah,
How much confidence do you have in state legislatures?
I don't. Yeah. So I think that, and the big question of does the ministerial exception apply to employees of religious charter schools? Like, that's the whole game. If you cannot hire for your faith, you are not a faith-based school, period.
All right, I'm going to take questions from the audience. We have some microphones coming around, so if you have a question in the audience, go ahead and raise your hand for me, nice and tall. We do have 2 rules here at AEI for audience questions. The first is just tell us your name, and the second one is to ask a question. So please follow that rule. I have, do I have a microphone? Right over here in the front, we have a question.
All right, well, thank you for the great debate. My name is Justin Drewer, and this is mainly a question for the affirmation, but I guess anyone who wants to jump in, feel free. So why does Trinity Lutheran apply to the Oklahoma charter school case? How is the affirmative founding of a Catholic school a public benefit, which would not exist but for state funding, rather than being a church tax by a different name versus a pre-existing playground program? And then also, does it matter that a playground is not as involved with the advancement of a religious doctrine, versus the curriculum of a Catholic school, which would have, I guess, run closer to running afoul of the Establishment Clause?
Do you want to start?
Sure. So, the key case there is the one that followed that is Espinoza. And there the court said you can't really draw this. In Trinity, they said there's a status versus use distinction, and that the Trinity Lutheran Church was being discriminated against simply because of its religious status. That was a very unstable distinction. Some of the concurrences pointed that out. And they started moving away from that. Money's fungible after all. And many religious schools say that everything that they do somehow involves their religion, even things that would happen on a playground. And also, again, since it's fungible, if you get money for the playground, that can free up money for other for religious instruction. So and this is where Justice Breyer, he said, well, I would like to draw a distinction here. And the majority in Espinoza said you just can't draw a principal distinction. It's going to lead to doctrinal chaos if we do that. So that's why, there was the Montana Blaine Amendment that was at issue. There was not a Blaine Amendment at issue in Maine, but it was essentially a law that acted like a Blaine Amendment. And for those reasons, it applies to Oklahoma. It's the same kind of reason. Are you excluding entities simply because of their religious beliefs?
Can I say something briefly on this?
Quickly, yes.
So for anyone who's really interested in this question, this status-use distinction is so fascinating. I'd commend this case, probably 20, 25 years old, called Locke v. Davey, out of, I think, Washington, that got into this. It's whether or not you're being excluded just because of your status as a faith-based organization, or you're using money for faith-based reasons. It appears that the court has cabined that decision just related to this particular case in Washington, but if for some reason Roberts decides to go along with that thinking, that could be one of the ways that they don't end up going on our side. But one thing that I want to point out is that under state constitutions, it is true that every single state constitution charges the state government with the obligation of making sure that a public education system is provided. No doubt about that. But if you read those provisions, it is astonishing the passive construction of those provisions in the state constitution. It does not say the state government must run all public schools. It doesn't even say that the state must delegate the operation of public schools to itself or to other state entities. It says that the state government must ensure that a public education system is provided. And this is clear across all 50 state constitutions. What that is saying is that the state government gets to decide, once it recognizes its obligation to make sure public schools are provided, the state government gets to decide how those schools are provided. Under chartering, they have decided in the public interest, in the public good, the government, districts, the state government, county governments, in the case of New Jersey, can run public schools. Nonprofits can do it as well, and in this case, faith-based.
Response?
Yeah, not so much. So, there's various terms of art in there. They term common schools, right, which is a key issue in a lot of them. They talk about uniform systems. They also create state boards of education. Some of them actually even create local school districts. So this idea that you can just do whatever you want, not true. Over half the states have had state constitutional litigation around school funding and other things to prove to states that you just can't do whatever you want to do. But I do want to come back and can do something rather unusual, because I think it's clarifying for the audience, which is to concede a point, right? So there's a distinction in my mind between the state saying, look, we want to run public schools, and anybody who's willing to meet our objectives, our secular objectives, our math objectives, our history objectives, is welcome to do it, except for religious schools. I would concede, or I should say religious entities, that is probably a problem, right? Probably is unconstitutional under those line of cases, which is to say, if a religious institution is willing to do exactly what the state wants it to do, then excluding it is inappropriate. And I think this is some of Kathleen's concern, which is, well, yeah, you can do it, but only if you do it like us. So that's number one. And if you don't hold to that rule, right, and you say, no, it means more than that, which is, we've got our rules of what public schools are, but now you're going to come in and change all the state's rules and teach whatever you want and spread religion or indoctrinate children. That's the distinction here, the distinction between, can you check your religion at the door and run a charter school? Yes, you can. But if you're unwilling to check your religion and you insist that the public school is going to become a private school called a charter and teach religion as truth, then you've crossed the boundary under state and federal constitutional law.
Yeah, I have a question, and it's going to come back to this side first, but I think both will want to look at it. And it's basically that the U.S. may be kind of an outlier here. There's many other countries that have state-funded religious schools. UK, Ireland, France, Australia, even some in our neighbor to the north, Canada. If it works for them, why not in the U.S.? Those arguing against, can I get the first crack from you?
I mean, I think the examples from our neighbors, particularly in Canada, but also in other countries, is that the publicly funded religious schools do have to water down their faith in order to accept the government funding, which is why in many of those countries, particularly in Canada, you have Catholic institutions trying to open private Catholic schools so that they have the freedom to live out their faith in ways that are true to their values and where they do not have to make the compromises that this contract with the government is requiring.
Yeah, and I don't think it really, I mean, there is the policy question, which I think we could have a very long debate about what's going to happen. We don't know. But then there's this sort of constitutional question again, and the answer is, regardless of whether it's good policy, to be quite honest, like America is different, right? Jefferson and Madison came here in part because they didn't like the fact that other countries were raising taxes and giving it to private entities and churches. And so that's why we have an establishment clause. America's unique in lots of ways, right? They don't have guns in lots of places in Europe. And we do. Why? Because we put that in our Constitution. So on this question of the constitutionality, it doesn't matter what we want. It matters what the Constitution says.
Questions from the audience? I have one back here.
Thank you. My name is Mike Donnelly. If I'm not mistaken, the United States of America is a constitutional republic comprised of 50 laboratories of democracy. So why should 5 out of 9 Supreme Court justices get to tell the states how to operate their education systems when education is not in the Constitution? So isn't it time to unincorporate the First Amendment, or at least that portion of the First Amendment that is bringing this matter to the Supreme Court? Maybe this is an impractical thought exercise, but I'd appreciate your insight.
Wow. I will not argue for reversing the incorporation of the First Amendment to apply to the states. I think that Justice Jackson's opinion in West Virginia versus Barnett is very powerful on this. Yes, you can provide education, but you, as Derek has said, you are obligated to under state constitutions, but you must do so in a way that complies with the Constitution. So. Yeah, I'm not willing to relax on that.
But actually, it's sort of funny. It's like you said, a little something I like and a little something you didn't like. But yeah, I think you make a major point, and it's in my amicus brief, which is ultimately states do run their education systems, right? That they have the right to make a number of policy decisions. And the idea that this Supreme Court would strip that autonomy, to strip that policy decision from the states, flies in the face of everything that we know about public education.
I look at it differently, which is the federal government, there are 2 provisions in the religion portion of the First Amendment, free exercise and the Establishment Clause. When the state governments decided to bifurcate public education into 2 different sectors, it is absolutely clear that the sector of public education that is run by the government has to follow all of these rules related to the Establishment Clause. It cannot establish a religion. There cannot be district-run Lutheran schools or Jewish day schools. Absolutely true. But the First Amendment's provision on free exercise is extraordinarily helpful for all of us here. It says in that second sector of public education, when nonprofits are running them, that you will not be punished whether you have a faith or don't have a faith, or regardless of which type of faith you have. In that sector of non-government schools, nonprofit run, the First Amendment says it doesn't matter if you're Lutheran, Catholic, none of the above, all of you get have an equal chance to participate in this. Thank goodness there's that second portion of the First Amendment's religion clause.
I've got one last question right up here in the front. And Kathleen, I'm assuming you don't want to weigh in on prohibiting religious charters versus the First Amendment. So,
hello, my name is Gauhar Dauletova. I am from Central Asia, Kazakhstan. And I have a question. Like, in Kazakhstan, there has been a noticeable decline in interest in religious school. We don't have Catholic schools in Kazakhstan. And this trend is often linked to growing public concern, especially in the aftermath of events in the Middle East, that radical ideologies could potentially infiltrate educational environments. And while most religious schools promote peace and moral values, in today's climate of global instability, societies are becoming increasingly sensitive to issues of security. And my question is, do similar risk of this kind of ideological influence exist within religious school in the United States, especially in the context of global threats? How do the states, civil society, and the school themselves respond to these challenges while upholding the right to freedom or religion?
that is an excellent question. Thank you very much. Let me give it to you briefly. Is the concern correct? I mean, where is the limiting principle here when ideology can be pretty potent? And are all the little flowers going to be allowed to grow in the in this potentially open field?
Potentially, but I think that already is happening. We are the idea that we don't have ideological commitments, and that particular schools don't have ideological commitments. Even public schools, which are supposed to be neutral, you actually look at them, they often quite clearly have contested commitments that show up before the Supreme Court, including in this term, one from Montgomery County about the assignment of books in elementary school. So the idea that this is somehow going to create more conflict, I'm not certain that that's the case. I would reject it. I actually think they can limit some of the conflict. In fact, as students can have choice and parents can have choice about where they can send their children, that could then alleviate some of the pressure over some of these cultural contests and values that we see in public education.
Very briefly, is this a real concern, or is it sort of an overwrought concern that there's no limiting principle if this one's taken down?
Well, I hadn't considered it, but I think the question raises a very important point, and Josh sort of doubles down on it, which is, look, whatever schools are doing or not doing in Montgomery County, the Constitution places a limit on them, right? If the Supreme Court says that this is indoctrination that crosses the First Amendment line, that will be declared unconstitutional. But if we move to a place in which we say religious charter schools are not public, they're not subject to the Constitution, and therefore they can move forward and teach whatever they believe to be religious doctrine, there is no limiting principle. And I think that's another important point to just sort of drill down on, which is it's not the business of government to say how much religion is too much or which religious ideas are good ideas. And once it starts authorizing some religious ideas, it has to authorize them all.
All right, Derek gets the last word in this section because it's time to move to closing arguments. The debates move quickly. We have, in the same order that we had opening addresses, we have closing statements of 2 minutes. Let's start with Andy Smerrick.
Wow. This place, AEI, is wonderful. It's been fighting for school choice and sort of like a choice-based, expansive approach to diversification of options for ages. But also there were two scholars here who did some work, Berger and Newhouse, who were like famous for what's called communitarianism. There is a view in America, it goes all the way back to Tocqueville, that what makes us special is that people self-organize in all types of different ways to do things in the public good. And just because they're not doing it through the government doesn't mean it's not for the public good. And when you have a nation conceived in liberty that is stretched across a continent, where people with all these different traditions and customs and beliefs, the only way that we can stick together as a whole, e pluribus unum, is if we recognize the pluribus part. And so there are people who believe in Montessori education, God bless them. There are people who believe in outward bound expeditionary learning, bless them. There are people who believe in classical education. There are people who believe in anti-racist education. Great, that is what makes America America. The idea behind communitarianism, at least has been articulated for 30, 40 years, is that all of these nonprofit groups, if they're advancing the public good, have a right to engage in the stuff of public life, even engaging with the government in carrying out the public good. I think it's really unfortunate that for so long we have said to America's wonderful civil society, everyone has the right to participate in running public schools, except if you're associated with a faith tradition. That is not in our best traditions. What is in our best traditions with education is to say all of these groups can participate as long as they are meeting the criteria in the state statute that they're going to have great academic outcomes, they're going to follow these rules of their authorizers, but we're not going to judge you based on whether or not you think Cicero is right or Aquinas is right. We're not going to judge you whether or not you think that kids have to do hands-on learning or if they need to read a whole bunch. As long as there's performance-based accountability, all of America's tapestry gets to play a role in this, and we should include faith-based groups in it.
Thank you, Andy Smerick, and Aquinas all the way down. But Derek Black.
Yeah, on this fundamental question of whether charters are state actors, we can't pick and choose, right? We have treated them as state actors for the last 20 years. We had the Fourth Circuit Court of Appeals telling a small private school, I should say a small charter school that claimed it was private, that it couldn't discriminate against women because it is a public school, right? And if we are, since we can't pick and choose, if we exempt charter schools from the Establishment Clause, then that means they're going to get exempted from the Equal Protection Clause as well, leaving students across this country, 4 million of them, without rights. And on the policy side, you know, we've heard a lot about, well, it's just a small thing, it's not a big deal. Like, you know, either they haven't thought about the consequences of what they're asking for, or they're not being honest with you, right? You take the current public education budget, you absorb lots of struggling charter schools, religious charter schools, Catholic schools that we've talked about. Unless we raise taxes, then that means the pieces of the pie are going to be smaller for all the children who are currently in public schools. And imagine another scenario. Imagine a rural community that has one high school, right? And the local Baptist church, maybe a local Presbyterian church decides it wants a charter, and the state is now required to give it to them. Imagine then that small public school craters. It cannot continue to function. It has lost too many students. Some might say that's how choice works. But guess what? The kids that are left behind, they don't have a choice. There's no public school left to go to. Their choice is to go to the Baptist or the Presbyterian church, or maybe to no church at all, because if they are exempted from the Constitution, they're not even required to accept that student. So as we walk further and further down this road, you see a disastrous set of consequences, not just for schools and institutions, but actually for the children, and the children who want the choice of a public school.
All right, thank you, Derek. Josh?
So on that last point, since we've seen rural schools survive with the advent of charter schools already, I don't think that the faith-based charter schools are going to be catastrophic for rural schools. I don't think there's going to be a dramatic change in how many students are going to enroll in them. So I would not be concerned about that. I would also say that faith-based individuals can already create these charter schools, which is actually part of the problem. You can create a nonprofit, but just kind of hide your religious commitments, and then all of a sudden that's okay. And then you can establish a charter school. There seems to be something fundamentally wrong with that under the Free Exercise Clause, where you're actually kind of forced to deny your religious motivations in order to receive this public benefit. And on the state action doctrine, the state had no role in creating or administering St. Isidore. The state recognition is not the same thing as state creation. To say that the school was a state actor would essentially absorb vast swaths of civil society under state control. Private charities that perform public functions and receive public support could be subsumed under this state action doctrine. Even for-profit companies might not be exempt. You think about energy, agribusiness, technology, and healthcare corporations, all of which receive some support directly or indirectly because we regard their functions as publicly important. They could be absorbed into this. Inviting courts to draw lines between these kinds of activities would simply invite chaos. To go back to the constitutional question, we experienced decades of chaos under the Free Exercise Clause and the Establishment Clause. The Supreme Court is trying to clarify what's required on it, and to draw this kind of arbitrary line would just return us to this period where no one knew exactly what was constitutional and unconstitutional. So for those reasons, I think St. Isidore should win.
All right, and last but not least, Kathleen.
So when considering the policy side, let me say this. We've mostly waved away a lot of the messy details, but the devil lies squarely in those details. So can a faith-based charter school have the freedom to hire and fire for their faith and in line with their values? How much freedom do they have over curriculum in this public accountability system? Do they have the freedom to fully teach their faith and their values as they want to, or only in a government-approved way? And those details matter when it comes to a school being an authentically faith-based school. So St. Paul said in 1 Corinthians that all things may be lawful, but not all things are helpful. And our challenge here is to separate the two. Religious charter schools may be legally permissible, but they are not pastorally prudent. They may offer short-term financial relief, but they carry much larger, longer-term risks to the mission of the church and to the constitutional guarantee of religious freedom. And ultimately, they dilute the very thing that gives faith-based education its power, which is its independence.
Thank you, Kathleen. And now the decision lies with the audience. So it is time to vote. This is a new QR code. It is a new address to go to. So you can please go and vote against or for the motion after hearing the intelligent and civil arguments by our debaters, which I greatly appreciate. Again, the motion: the U.S. Supreme Court should rule in favor of Oklahoma's religious charter school. It's right on the law and policy. And while we're waiting for those votes, I have a question. One thing that did not come up in this case, we had a recusal of one justice. So we are in this situation where Amy Coney Barrett is not going to be voting. So we could have potentially a 4-4 split that would leave the Oklahoma State ruling against St. Isidore in place. So I'm going to ask my debaters, while we're wrapping up voting, you have just a few seconds. Quickly, what do you expect the vote to be?
First of all, let's say thank you to Nat for bringing us all together. This was really fun. I appreciate that. So your question is like not an idle one. If you remember the public union case, happened right after Justice Scalia died, and that was 4-4. And so we had to wait for the next case, and then it ultimately went, I guess, 5-4. So I find it really hard to believe that Chief Justice Roberts would have written the previous 3 decisions in the way that he did, and then not write a decision on our side for this one. I find it hard to believe that Gorsuch, Thomas, would not, and certainly Alito, be strongly in favor of this. Kavanaugh is, I think, a question mark. Maybe not, though. So I think that it's going to go 5-3. We'll see.
Josh?
5-3 or 4-4. Roberts, I think, is the wild card because he is a minimalist. He likes to proceed very, very cautiously, and he actually kind of held back the others in that trilogy of cases. So I'd be hard pressed to put money on either one of those, but it's 5-3 or 4-4.
I defer to my constitutional law scholars.
All right. Kathleen defers.
I mean, I'll say, I'm not going to answer your question. I don't have a problem with the premise. The reason why I'm not going to answer is not because I lack confidence. It's actually, I think, for anybody that's listening at home, is something important, which is the rule of law. And look, maybe this comes out to my benefit. Amy Coney Barrett's not on there. But look, there were members of the court. Kagan recused herself in affirmative action cases when she'd worked with the government. And I'll just have to say that, I have an enormous amount of respect for her for having recused, given that she thought she had a personal, or she does have a personal relationship with one of the sort of lead movers in this area. And I think, the constitutional law scholar in me wants to say, we need to respect our justices, and I respect her for doing that. We've had a lot of justices that don't recuse under situations that are questionable. And then just sort of one last word on that. Some people have criticized her for recusing. They've criticized her for other decisions. And I'll have to say, look, I've sort of gotten in her corner over the last couple of years, not because I agree with all of her decisions, but because I have enormous respect for her integrity. And I think if we had more judges like her, I think we'd have a better judiciary and we'd have more respect for the judiciary.
All right. Well, speaking of judgments, we have one to go over. So here are the results. In round one, those voting for the motion was 22% of the audience was for the motion, and in round two, 51% was against the motion. I'm sorry, in round one. So 22 for and 51% against. In round two, 17% for, that's a drop of 5 points. And those approving the motion, 78% for a net gain of 27 points. So those against the motion have won tonight's debate. I want to thank our audience. I really want to thank our debaters. This was an excellent model of civil engagement and honest discussion on an important issue, and we'll see how the real deal plays out in a few months.
Could you give those numbers again?